Hello, everybody.
Good.
I'm not going to introduce myself again because you've heard that twice. In an effort to move the meeting along quickly, we have two board members who are recused on the rest of the evening, and so we need them for a decision. So rather than having to wait to the end of a hearing that could be kind of lengthy, I am going to make a motion to move the decisions to the top of the agenda.
Second.
All in favor? Okay, okay. All right. The decision is for Blue Door Resorts, Inc., Plat 6, Lot 140, fire number 61, Dodge Street, application by Ann Law for a variance from sections 113 for construction of a dormer to add life safety stair improvement. I have some notes on that. I move to approve the application by Blue Door Resorts, Inc., Plat 6, Lot 140 for a variance from sections 113 for the construction of a dormer to add life safety stair improvement. This decision is based on the following findings of fact. The property is located in the Old Harbor Commercial Zone. It is a pre-existing non-conforming property by size and building locations. The property consists of an inn, 2 guest cottages, a shed, and a retail office building. The lot is 6,339.40 square feet in size. There is a discrepancy in the application on that.
Okay.
The site plan cites the 6339 number.
Okay.
But we just probably need to make sure that that's all consistent. Excuse me, the lot is 6,339 .4 square feet in size. 20,000 square feet is required in the Old Harbor Commercial Zone. The total existing building lot coverage on the property is 2,839 square feet or 44.78%. 50% building lot coverage is permitted in this zone. The subject building is referred to as the larger guest house in the application and as guest house on the site plan, applicant's exhibit 1. It should be noted that there are 2 buildings labeled guest house on the site plan. The subject building is the building in the northwest corner of the property. The subject building sits directly on the northern boundary and sits entirely within the rear setback. The applicant is requesting to add a dormer to the second story of the north side of the building. This would result in the expansion of living space with the rear setback and within the rear setback. Excuse me. This nonconformance requires a dimensional variance pursuant to section 113. The applicant testified that the dormer is necessary to accommodate a safer staircase and that meets safety codes, replacing a staircase that did not meet fire and safety code. The footprint of the building will not expand. All other buildings on the property will remain the same. The hardship from which the applicant seeks relief is due to the unique characteristics of the subject land or structures and not the general characteristics of the surrounding area, and is not due to the physical and economic disability of the applicant. The hardship sought to be avoided is not the result of any prior action by the applicant. The hardship is not the result of any prior action of the applicant. The granting of the requested variance will not alter the general character of the surrounding area or impair the intent or purpose of the zoning ordinance or the comprehensive plan on which the ordinance is based. The hardship that will be suffered by the owner of the subject property if the relief is not granted amounts to more than a mere inconvenience, meaning that relief sought is minimal to a reasonable enjoyment of the permitted use to which the property is proposed to be devoted. This decision is subject to the following stipulation. The dormer shall be constructed in strict conformance with the site plan and building plan submitted.
Second.
Any discussion? No? All in favor?
Aye.
Aye. Great. Okay. Thank you. Okay, the public hearing of the evening is for 1167 Gracie's Cove. I gotta go back to the application. Oh, sorry, skipping right around. Sorry, Beth. Okay, the first application of the evening is VVO Real Estate Holding Inc., Plat 6, Lot 107, fire number 41 Water Street. Application for a variance from Article 3, Section 311C, maximum height to reconstruct the Harborside Hotel, which was destroyed in the fire of August 2023.
Hi, good evening. How are you?
Hi, Beth.
My name is Elizabeth Newman, and I'm an attorney with the law firm of Dallas Power, and I represent VVO, who's the owner of the property and the Harborside. As you all know, the Harborside went down in August of 2023. We're seeking to rebuild it and we need a height variance. We don't need a lot of the other stuff because it's non-conforming use and the ordinance is allowed to rebuild. Yeah, we're doing it, and it's been through the architect and Montecchio has taken this to our district commission through preliminary approval. We're looking to be heard for you for the height So, okay, we move forward with the architect. And we talk about it, but we do know like there is plenty to why we need policy.
Okay, I'd be prepared to come to the meeting. Why you need so much height relief? We've never granted a height variance before in my, I don't think in the Judith isn't here. Bob, you're next. There's just, it's just typical, it's just very, I mean, it's since 1999, I think I've been on the board, and there is a first time for everything, but I would become prepared for that. And I understand that there's the cupola ordinance and the demolition and all that, but there is a discrepancy in the height allowed in a cupola versus what you're proposing. And also, I would like to see on the site plan, and the building plans on the elevations, exactly what the height of the cupola is. If you could have Glenn add that. It's just that number isn't there. Did anybody else have any questions for Beth or want to see something?
What's the cupola?
It's section it's 44.1. It's a definition. It falls into the definition, and it basically talks about what it is, but then it says the size of a cupola shall be proportionate to the size of the building and it shall not exceed 15% of the length of the principal ridge line on which the cupola is placed, or 4 feet above the maximum permitted building height.
Okay.
So if 40 feet is permitted, they can't exceed 44,
So does that?
but it's that
require-
or.
Does that require a variance or something? Because it's not that's not in the application right now.
No,
is it-
the ordinance reads that certain architectural features of a building and lists a cupola are exempt from height. However, under 44.1, to be a proper cupola, that's like, there we go, cupola, you have to meet all the standards in that definition.
Right. What I'm
Okay,
saying,
so
just looking at the drawings as they are, it exceeds both of those numbers.
Right.
Correct.
Yeah,
Yeah.
That'd be great.
It's about 12 feet.
Yeah.
it's just hard. It was hard. It's hard with those numbers. I just, you come prepared. Mark, do you want to read that?
No, I did.
Oh, you did?
I just,
Okay.
I'm just wondering if the application needs to be adjusted for that. And you're saying no?
No, I believe it's the applicant's position, and I'm sure she'll correct me if I'm wrong, that the cupola, since it complies with 44.1, is not included in the height. Therefore, no additional variance would be required.
What I'm saying as the drawings are submitted, it doesn't comply with 44.1.
No, I believe they're saying it does.
Yeah, I will, report that.
Okay.
Let me just
Yes.
confirm that with Glenn.
Yeah, I just did the math and I
Yeah.
can't see
Yeah.
how it does, but
I'll verify with him. Obviously, our goal would be to comply with 44.1 and then just go to high variance structure and then reasons for that.
Okay.
And the HDC approved the one.
They approved the whole plan at preliminary approval, so yes, we're good. But I wasn't at those hearings. I don't know if they've got these measurements for height.
So I'm just
Karen, is there
scheduling
a
this, right?
decision for HDC for the plans and the cupola, do you know?
I do not know the answer to that. I can find out.
Massing, and then, I think they asked 3 different back. I wasn't at those hearings, so.
Okay, if any other questions? I'm gonna schedule this for the May meeting, right? Which is-
Actually, I'm sorry, I
Yeah.
do have a couple of things, on the application, stated you did not have a height of the pre-existing building.
I don't believe we had one.
Is there a possibility of getting photos of the old building? And also heights of the neighboring buildings, such as New Shoreham House, as well as Oddfellows, so we can see it in relation. I also was curious about 113C2 on the zoning ordinance, under non-conforming buildings, construction, and demolition.
Right.
Now you stated you didn't need any other variances for that based on a fire. But under this, it says if non-conforming building or structure is demolished or removed by or for its owner, it shall not be rebuilt or replaced except in conformity with the dimensional requirements of the zoning ordinance. Which it also talks about in that same section, even if which is destroyed or damaged by any means beyond the control of the owner.
Right, so I mean,
That's what he's,
It's involuntary.
that's what they're asking.
Involuntary demo,
versus by not.
then you have to conform.
It's exactly the situation. Fire. And
Okay, so any other questions?
is that,
May 22nd. I'll make a motion to schedule this for the May 22nd meeting.
Second.
Any discussion? All in favor? Thank you. Okay. Okay, the public hearing of the evening is for 1167 Graces Cove Road LLC, plat 19, lot 72-1, fire number 1167 Graces Cove Road, appeal filed by John and Sharon Lehman for a letter dated August 8th, 2023 from the zoning official regarding a complaint filed regarding Lamb's package service. Couple things I want to say before we get going. The way that we handle appeals are typically, we're doing this a little different tonight, the appellant will go first. Then the zoning official will present their findings and why they came to the decision. We will then open it up to the public. And then for comment, if you have anything to ask to the appellant or to Jen or to the board, please direct everything at the board, not to each other. Everything comes through us. And you will get to speak. You can, how do you feel about that?
The law is that there is no right to cross-examination. That is up to the chair. There is the option of allowing Attorney Priestley to cross-examine directly if you so choose. There's also the option of no cross. There's also a medium option of having questions posed through the board, through the chair. So it's
Okay.
up to the chair.
Oh, I'd like to talk about it. How does everybody feel about that? I just don't, we don't want this to get into like a firing squad situation. It's for anybody. We want everybody to be treated fairly and with respect. So, I'd like my attorney to.
Yeah, I mean, if Mr. Priestley has questions, he's certainly free to pose them.
Mhm.
And to the extent that the zoning official or I can answer them, we will do our best. But again, there's no right to direct cross-examination
Okay.
of the
Oh,
party.
great. That being said, please keep your comments and questions relevant to the zoning ordinance and its standards, not to whether or not we need package services on Block Island or, there's something happening in some other zone, whatever it is. This is all relevant to this appeal. It's our job to determine whether or not the activity at the property is a violation of the zoning ordinance. That's our job, not any of the other issues. And then before we get going, I would like Karen, our attorney, to explain we don't actually have to hear this appeal, and I can't explain it clearly, so Karen will explain it.
Yeah, so at the top, I just want to ask Madam Chair that all memoranda and associated exhibits be made part of the record. I
Mhm.
think that'll cut down on parties having to introduce exhibits. I know that Mr. Priestley Attorney Priestley, excuse me, filed some papers. My office also filed some papers. To the extent, those have exhibits, I'd ask that all of that already be made part of the record to make for ease of
Mhm.
in this case, the zoning official found that there was no violation. The law in Rhode Island is that a finding of no violation is akin to what's called a zoning certificate. A zoning certificate is advisory in nature. And courts are clear that there is no right to appeal an advisory determination. For that reason, the appellants in this case do not have the required standing that they would need to come before you on an appeal.
And it's our decision whether or not we hear it. And because this all came out after this ball had started rolling, and there's a lot of time and effort has been spent on a lot of people's time and efforts have been spent, I felt that it was that we should hear it. And I don't know how the rest of the board feels about that.
So besides coming to this board, is there any other way for the parties to gain standing to challenge the decision?
Not to gain standing to challenge the decision, but if the appellants so choose, they could request a zoning ordinance amendment from the town council. Now, I don't know what I don't know what that would look like. I don't know what the council would do with something like that, but that would be an avenue if they so choose.
So there is another avenue.
They can't go to court,
They can't what?
go to court.
No, there's no right of appeal. They have no standing.
No standing.
Because they have no standing.
Okay, so does I feel it's important to move forward with this. We feel so much time and energy has been spent on it, on both parties.
Ask the question. If they don't have standing, the board goes forward. Isn't the board's decision going to be void?
Yes. Yeah, I mean, if the board should decide to uphold the decision of the
Okay.
zoning official, it's a nullity. If they should find against, it's also a nullity because there's no jurisdiction to hear it in the first place.
So we're not at risk by hearing it.
No, but any action you take wouldn't have an effect.
And Bob, you have to use your microphone.
I'm sorry.
No.
I asked, I said, are we at risk, but is the town at risk by hearing,
By hearing it.
by hearing? Okay.
What I will say is that if you should decide that there was a violation, it becomes a legal quandary in the sense of, I would expect Attorney Priestley's client would want to appeal. And it would be my position that your decision didn't have legal grounds. You didn't have a legal ground to make the decision in the first place because there was nothing before you. So it
So
could,
then we
in
should-
that case, it might cause the attorneys involved to pull our hair out a bit to figure out that scenario.
So then we shouldn't be here.
That is
crazy.
legally, there's no standing. That's all I can say.
Yeah.
Okay,
And so Kate, so why, besides they put a lot of work into this, why do you think we should hear it?
I think because this got brought up to us after we had already started, the appeal had already been filed. That was when that was in December. When did you, that is December with them?
November.
November. It had already been underway a little bit. I just feel like they're here. They've spent a lot of time and effort, and Jen has spent a lot of time and effort, and the Becks, everybody has a lot invested in it. And
I've read all the brief, everything.
I mean, it's a lot of, for them to just say, well, sorry, we're not going to hear it. I just feel at this point, the ball's been rolling, and that's, it's neither here nor there, but
You don't feel that since the outcome doesn't really matter, it's moved.
we can vote on it, whether or not we
No,
hear
I
it.
don't-
I'm
don't care.
I'm happy to,
I would suggest that you put it to a vote,
all right, well,
Do it.
I will make a motion.
given the discussion.
I will make a motion to hear the appeal.
Second.
Okay. That didn't carry.
Did you vote?
Nobody voted.
It was just
We
a
voted.
second.
Just
Motion
second.
carried.
Oh, you didn't carry, you
Nobody
voted, you voted.
I just seconded it.
I'm so good at
Bob,
this.
second, okay.
All in favor?
Aye.
Right.
Aye. Okay.
Okay.
Sorry about that confusion. Okay, so, I'm gonna just shut this. You're up.
Thanks for.
So you're gonna have to be sworn in. Anybody, just for the record, anybody that testifies or gets up to speak, if you're gonna give testimony, you need to be sworn in by Sally. Or Karen, sorry. I'm used to
Could you-
the other one.
Could you raise your right hand? And state your name for the record, please? And Mr. Liam, what is your address? And do you swear to tell the truth, the whole truth, and nothing but the truth during the course of this hearing? Thank you.
Thinking about this for at least 3 years anyway. We've been talking about it. I'm not sure what the caveats were that you were talking about, because I don't understand a lot of the legal aspects of it. Although I did order a torts class in 1960. And
That's how we had Karen explain it.
I'm so happy that I didn't should say. Anyway, I first came to Black Island in 1966, and Sharon and I have figured out that we've been here a combined 100 years. We love this place. We desperately don't want it to change despite all the other stuff, and that is really the principal reason that we started this investigation in the beginning. I guess I should say, if the appeal was illegal, do we get our money back? Anyway, so actually, my son is here, Sharon's son, our son, and he knows a lot more than I do about this business. Yeah, I guess I would be smarter not to go through the things that I thought you were saying and let him just get involved in this. I'm sorry that it's worked out this way, and I must say, the number of, what are we calling them? Legal briefs, the amount of legal briefs that have surfaced in the last 3 days of scared the heart out of me.
It's a lot of information.
So, this is Frank.
Okay, Frank, you can, need to get sworn in.
Could you raise your right hand? You state your name for the record? And what is your address?
Street in Mohawk.
And I'm sorry, did you swear to tell the truth, the whole truth, nothing but the truth during the course of this?
I did.
Thank you. Could you
I
explain about this?
So thank you for taking the time, follow along the experience of the last 3 years. Been interesting. I served there for 8 years on zoning board. This is the first time I've ever actually appeared before a zoning board, and I'm strangely nervous. So I'm kind of expecting this is what people were like around me. I say, like, where I was, we had a big high day, so we had a lot more.
We're tougher.
I just want to approach this. I don't know what I thought. I do believe that the leanings are correct and that the opinion should be first. I'm going to give you a set of understandings. Needs to be wrong, and not wrong, but I want to go through that very briefly so you understand. My understanding is that the property at 1167 Basis Cove Road is owned by an LLC, 1167 Basis Cove Road LLC, and that the company that operates on the property, and I know there's even this discussion about whether a company operates on the property, but for the purpose of my conversation, I'd just like to say that company, that's the state of Rhode Island, says company lands package service operates at 1167 Basis Cove Road, and that the primary employee of this company is a fellow named Grant Beck, who is a resident of the property at 1167 Basis Cove. And it is my understanding that the basis for allowing lands package service to operate at 1167 Basis Cove Road is that Grant Beck is the resident at that property. And under the zoning code, and I agree, the zoning code permits any person who working for gain, is the term part in the zoning code, is allowed to operate a business at the place where they live, and it's immaterial whether they own it or their renters. And so it seems to me that it's an adequate proposition to say that the residents of Green Beck on the property would allow Green Beck to operate an accessory business use on that site. The rest of it is where I diverge from my opinion. The first one is that the zoning code is very unclear as to whether the permission to have an accessory use goes towards being an employee of the company in which has the accessory use. Grant Beck is not the owner of the Amstrad. The state of Rhode Island, the most recent annual report filed just 4 days ago, says that the vice president is Deirdre Beck. And in numerous applications before this board, nobody has represented that Grant Beck is the owner. So I believe if you're setting I don't believe that you have the authority to be able to allow an employee to use their right as a resident, that being the gain that is cited in the zoning. So that's my first concern about that. Because if you can't claim a rightful accessory use, everything else falls to the wayside. There's really nothing left and the business can't operate. So the first question I would ask to you, which I believe that you're not allowed to lease out your right to have an accessory use, either on Block Island or in the state of Rhode Island. The second one goes to employees. Zoning code is very clear. That's stated that they don't just have one employee, that's the zoning code says clearly. The accessory use is only permitted one non-resident employee on site. And I don't think there's any doubt that land package service has more than one employee. The owners have said to the Providence Journal that they have more than one employee in a story about it. I know there was some discomfort about saying it, but land package service applied for a PPP loan in 2020, stating that they had 8 full-time employees. I don't think that there's any doubt that they have more than one. So in the briefs that I read, there seems to be a doubt as to what an employee is. And if I summarize correctly, an employee, the claim is that because they don't work on site, they don't count as an employee. Now, I find that peculiar. The zoning code is silent as to the definition of an employee. So this would be the first time that any board or any entity in the town of New Shoreham has ever made an assessment of what an employee is. Because what I'm reading from the briefs is they don't have 8 employees because they all go out in their trucks all day and they're on the road all day. They're never working at 1167 Graces Cove Road, so they kind of. Now, the zoning code says very clearly 1 employee. It doesn't say a part-time employee. It doesn't say a full-time employee. It doesn't say a 1099 employee. So you have no definition. Now, what I believe you would be saying by upholding this appeal is that there essentially is no definition of employee. If I wanted to say I had no employees, I'll say they're all 1099. By law, that isn't an employee. Legally, a 1099 person is not an employee. So any person in the town from now on, if you were to move forward with this, could say they're not an employee. And it would essentially gut this section of your zoning. And that's a problem. And so I respectfully say to you that unless the employees are forbidden from ever returning to 1167 Grace's Cove, that they're never allowed to go to the bathroom, they're never have a meeting with the boss if they've been messed up or they've done well, that you're essentially saying that it doesn't count if you're an employee if you leave and then you only come back and that's it. And I respectfully submit to you that that's impossible. And it's probably a violation of labor law too. We all agree that these employees are employees of Williams Trucking. They're not 1099 employees where they go to the bathroom. There are certain requirements under labor law you must provide to your employees. So they're either violating labor law, which is possible, or they're employees. They're coming and going to this location. So respectfully, I think that they are not following the code of this town because there is more than one on-site employee. And that gets us then to parking. My understanding of the briefs of counsel for the town, the briefs for the council, the vets, essentially say that because of the accessory use, all parking becomes legal, essentially sort of swept in. Because if the Becks lived, if Grant Beck lived across the street here, and you had 10 vans and trucks on Grace's Cove Road, that is clearly on its face a violation of zoning. Clearly, you're not allowed to have a parking lot. You can't rent the place out in a residential zone for parking lot. It's a violation. There's parking lots for tons of non-conforming uses on Block Island that people park on and that they're parking. But this is not a non-conforming use. This is a use that only came up a couple of years ago. So there's no other thing like the parking that they have over for the propane or any of these other folks that have things that have been around since prior to 57 years ago. So they're in a different world. This is a new condition that is not covered by a non-conforming. So what you're saying, at least the legal briefs say, is that if you're bringing in this accessory use, that covers all the parking because it's now part and parcel of this, what I believe, incorrect use. Because the parking would not be considered, would not be permitted if not for accessory use. But if the accessory use is invalid because the Becks have more than one employee, everything goes out the window. So I respectfully say to you that everything about the operation, in my view, violates the zoning code. And if you don't believe so, I believe that you're setting some pretty scary precedents for the use of land. Because what if they wanted to sell the property? What if they wanted to sell the property? Let's say they wanted to sell land as package service. It's America, sell your business. All you have to do to move it to anywhere else on the island is have a lease for that property. And now you've almost created a strange kind of spot zoning where these guys are allowed to go wherever they want to go because you said their employees are what they are. They're not really employees, and everybody else is going to do that. Every moped guy is not an employee. He works outside. Well, that's not an employee. He's a 1099. They're 1099. Everything about it's just not proper under your zoning. And I've read the briefs. I respect the attorneys. I just respectfully disagree. And I think that there's a different place to address this. And the town may or may not decide that this package service is important to the town, but that's not really what's at issue. What's at issue is simply with section 510 of your zoning code. You have accessory use, you don't have one employee, and if you're going to decide that an employee is not what the common meaning of the word employee is, then everybody's. So, with all due respect, I understand your hand strength, but I think there's a much bigger issue to play here than just trucks coming up and down. This is really at the heart of you guys. And your power and your authority to keep this place the way it should. So with that, okay.
Thank you. Does anybody have any questions? Yeah.
I do,
Oh,
not,
can you,
not for the witness, but for
Okay.
Karen.
Oh, sorry.
no, wait,
So Karen, in your brief, on page 5, it talks about the issue we discussed a little while ago. And it said, should we decide to hear the instant appeal, despite the fact that you're saying there's no standing, we must examine all the facts and any evidence and make a determination as to whether the activity complained of at the property is in violation of the ordinance. So you're saying, and then it goes on, and you're saying, it essentially says we have to make some kind of decision as to whether the complaint is valid or not.
No, what that is the paragraph you're talking about on page 5 is when the zoning board is sitting and hearing an appeal of a decision made by the zoning official. Your role is, in essence, to step into the shoes of the zoning official and to make the determination that's being asked.
So during this process, at the end, could the zoning official change the decision on the certificate that was issued?
No, the certificate has already been issued. The question is whether or not on appeal, the board should decide after looking at the evidence and weighing its credibility, whether or not the same determination would have been made or whether a different determination would have been made.
Okay, I was just struggling with that paragraph and the conversation we had a few minutes ago about,
I still am, because my question to you would be, is if we determined that the decision was wrong, if I heard you right before, it wouldn't matter.
If you decided that the decision was wrong, for example, if you decided that there was a violation or there is an existing violation, in essence, there's no standing for this, for you to hear this matter. So it could be that by issuing that decision and finding a violation, Lamb's package, I would expect, would appeal that decision, because now you found a violation of Lamb's package. If you should find that you uphold the zoning official's determination, you agree with it, you've stepped into her shoes, you weigh all the evidence here, and you decide the same thing, then there's no change.
But
That's
if,
the limit, which is why, since you don't have standing to hear this, you really shouldn't be hearing. Limit that the opportunity to make this case publicly. I think at this point, you really should close this down and acknowledge that you don't have standing. There's no point going forward. Our feelings won't be heard.
that's nice.
And it's likely that the Lehmans do not have standing to appeal to court. For the same reason that I explained about being before you here.
likely,
I feel like this is just like a
Mm.
spin.
Your first question is whether you want to hear it or not. And there was a motion, it was agreed that you were going to hear it. Now you move on to that page 5 standard. That is your role in reviewing the matter before you.
can I make a motion to close at this point?
You can make a motion.
I'll make a motion to close.
Can I just point out that you have not heard
We have not heard,
from others?
we haven't heard from others, so there's a lot, I mean,
As long as that motion is closed, we can drop the matter. We have no objection to it, but otherwise, Jenny, you heard me.
I don't know how to phrase my motion then.
Are you making a motion to reconsider?
No, I'm making a motion to close the hearing and drop the matter.
Then you've already you've already made a motion and it was approved to hear the matter. If you would like to if you would like to move to reconsider that motion, I believe under Robert's rules, that would be the appropriate thing to do.
To reconsider the motion.
I make a motion to reconsider hearing the case and to then drop the matter from the zoning board's agenda
For a lack of standing.
for a lack of standing.
The motion has been made. Anyone want to second that?
Okay.
No.
No one seconded?
I think we opened it and we gotta
Yeah, I think
Give
that this
everybody.
is,
their piece and then we can make
Yes.
some decisions.
okay.
Just final question, sorry.
Yeah, no,
I mean, I really wish this paragraph on page 5 hadn't even started, but can we still, at the end of this, can we still say, I don't know, we're not making any
do we have to even make a decision at the end? No.
Because this language implies that we have to make a decision.
No, that language is telling you what your role is, should you decide to hear an appeal from a zoning official's determination. If this was an appeal from the planning board, it would be a different standard. This is the legal standard that zoning boards of appeal apply when they're hearing appeals of a zoning official determination. Yes, if the decision had been to issue a notice of violation, this would be a different,
But that's-
Scenario.
This certificate is what makes it different.
exactly.
Got it, okay.
So
Thank you. Sorry for the.
if the complaint is brought forward and there's some, and Jen had found a violation, she would issue a notice of violation versus, just for the public, versus no violation.
Yeah.
So it's that difference. that-
Yes, so she has the legal power to issue notices of violation. There is no legal power to issue a notice of no violation. It's
the
a
no
zoning
violation
certificate.
becomes a zoning certificate.
I'm a little confused though with,
Okay.
I'm a little
I
confused
see.
in the sense that the zoning certificate doesn't necessarily is black letter law. The zoning certificate in itself.
As to issuing one?
Yeah.
Yes, there is a requirement and a time frame under which something has to be issued. But there is no content requirement to a zoning certificate. So for example, if someone asks for a zoning certificate and the zoning official issues it and says the zone is RA, the property is legal existing non-conforming. That information that's in the certificate is not necessarily legally required. The fact that it was issued, the timing on which it has to be issued is by statute. And if that doesn't happen, someone can come to the board and have it issued. But it's still an advisory
That's all.
certificate. There's no, if a zoning certificate is issued, you can't appeal a zoning certificate. It's only advisory.
Okay, I'm sorry.
I would say that if there was a change in circumstances such that an additional complaint came before the zoning official, a new determination, a new investigation could be started leading to maybe a different determination. But again, I believe there has to be some sort of change in the circumstances.
It's not an overturning, it's a new.
It would be a new investigation. And what was the second question?
No, it's
No, the certificate that's issued, or the determination or the decision that was issued here is purely advisory. wanted to rely on that determination? No, because zoning certificates are advisory, they cannot be relied.
That's so fascinating.
It's very, it's very fascinating.
It's like, wow. Okay. All right. Any other questions for them? Jen?
You state your name, correct?
Jennifer Brady,
And what is your position?
zoning official,
Where's your address?
1999 Ambrose Lane.
And do you swear to tell the truth, the whole truth, and nothing but the truth during the course of this hearing?
I do. I have exhibits to mark, so, I have the microphone.
And
Do you want me to put that over here? That yours? Okay.
Just for the record, with the briefs submitted were the exhibits for all the different parties.
But I have-
Jen is the only one that is submitting exhibits.
Right, I think I could. No, I can't. The matter before you is regarding Lamb's package service and a zoning complaint filed with the zoning official. In 2023, a formal complaint was filed and I began an investigation. I determined that plat 19 lot 72-1 is located in the residential A zoning district. Zoning officials exhibit 1 is a copy of the zoning ordinance, section 306 residential A zoning district.
I have a pen.
Accessory uses, home occupation are permitted use in the residential A zoning district. I reviewed section 202 definitions and section 510 accessory uses, home occupation. Actually, do you want to put that over there? I would like to submit the following exhibit, which is zoning ordinance section 510. Accessory uses, home occupation.
Applicant's exhibit 2 is 510 accessory uses.
On July 25th, 2023, I did a site visit of plat 19 lot 72-1. I contacted Dee Dee Beck and her son Grant Beck. During my investigation, I found the following. The vehicles were screened by vegetation and were not visible from the town road known as Gracie's Cove Road. I found that the vehicles associated with Lamb's package service were located greater than 50 feet from the primary access road. Zoning officials exhibit 3 is a site plan prepared by Jeffrey Rigby Leather and an OWTS plan by Gary Lamond, PE. I highlighted in yellow the parking area for the vehicles, and an area highlighted in pink shows the distance to Gracie's Cove Road.
Zoning officials exhibit 3 is a site plan as stated and the OWTS plan with highlighted pink and yellow.
Section 510 accessory uses, home occupation. Accessory uses shall not be advertised or identified on site. I did not find Lamb's package service to be advertised on lot 72-1. Only the vehicles have logos. Accessory uses shall be carried on by a resident of the property and no more than 1 non-resident employee. The property contains 2 accessory dwelling units, commonly known as 513s, and they are rented to employees of Lamb's package service. Grant Beck, the owner's son, also resides on the property. Accessory uses shall be conducted in a workshop, studio, or office entirely contained within a lawfully existing structure and shall not occupy more than 25% of the building footprint. Lamb's package service delivers UPS and FedEx to homes and businesses on the island. The operation takes place at Interstate Navigation, also known as the Block Island Ferry Lot. The packages arrive on the ferry and are sorted into trucks at the dock. Lot 19, lot 72-1 is located on the west side of the island, and no operation is taking place at that property. The parking or storage of equipment shall be confined to an area not exceeding 10% of the developable land area of the lot, located at least 50 feet from the primary access road and screened by a 6-foot hedge or fence. The property consists of approximately 80,000 square feet of developable land. The parking area is approximately 2,000 square feet, so that is 3% of the developable land area. So that, in my opinion, that complies. The on-site sale of anything other than products produced on the site is not an accessory use. I did not find any evidence of the on-site sale of goods. No package pickup, no Amazon storage lockers, and no distribution of packages is occurring. The accessory use shall not be permitted without the principal use to which it's related and shall conform to the standards set forth in this ordinance. The subject property contains a single-family dwelling and 2 accessory dwelling units. On August 3rd, 2023, I visited the property again and sat in my vehicle on the side of Grace's Cove Road near the property owner's driveway. I observed a fairly busy town-owned road. The road was used by vehicles, bikers, pedestrians, and a few commercial vehicles unrelated to Lamb's package service. It is a dirt road maintained by the town of New Shoreham and used for transportation. I found no evidence of excessive dust or noise. That's all I have.
Thank you. Does someone have a question for Jen? Okay.
You're currently the land use.
I'm also the administrative officer and the zoning official, correct? For 27 years.
Were you present for the meeting with the planning board when it adopted the 2016 comprehensive plan?
I was,
You familiar with
yes.
the concern, are you aware that 2 of the principal issues raised in the plan is the difficult issues on Long Island are year-round employee housing and parking?
Yes, I am aware of that.
I want to refer you to certain sections of, I'm actually going to first. And it's not good for, if you can follow along, because most of the exhibits.
Okay, Joe, if you're gonna start your whole,
I've got a whole question and answer thing for Jen, and then I have my own witnesses.
I know, but I
If
want
you want to mark, we can mark it, it's fine. Because
I would like to.
So
that
this
people
is,
can- Other people can ask questions of Jen too, and then if you're going.
property owners exhibit,
This is property owners exhibit 1. Okay. You want to mark?
I don't know what else is in that.
Attorney Priestley, question.
Is this your brief that you submitted to us already?
The brief you submitted, that's already been, you basically put all that's on the record, I'm just giving you your briefing.
Okay, so this is the same material that's already been in the record, nothing new.
They're on record.
Oh, to mark-
don't believe we have all of.
You don't have.
We don't have, so I'll mark, I'm just gonna mark this one and then if you did.
You don't have items 8, 9, and 10.
So thank you.
Which are the deeds to the land property and the location of the land, what's on the floor.
Stamp that.
Yeah.
And tab 4 is the housing, is the tab 3 is the comprehensive plan, economic, let's go back to the stats, so the comprehensive plan, housing section. Could you open that up and, page 61? it can be
What
read-
is-
We're
what is-
getting
what-
weeds.
I'm
No,
sorry,
no.
This isn't about housing.
Joe, I think we're getting in the weeds here.
Okay, this is about housing, because the use of the property is housing, and the use of the property is parking. The whole case here is not a case of a commercial use on the property. This is a case that involves employee housing, and parking for employee housing, and parking in general. So in that sense, it is about.
Employees.
And I
No.
didn't review any of this materials.
I don't think,
Yeah.
I don't think we go down this road.
I don't think it's, I mean, Karen,
It is up to the board whether to accept evidence as relevant or not.
I find
I
that
don't.
it's not relevant.
And in which case, here's what I say, this is not a case about an illegal commercial use in a residential A zone. Your zoning official has correctly concluded that there is no commercial operation going on the land property. The land will testify, or your official has found, the packages to be delivered by Lamb's Package Store, not delivered to the property. Packages to be delivered to Lamb's Package Store that are not stored on the property, and that none of the structures on the property are used by Lamb's, that's for Lamb's Package Store. They're used for single family dwelling unit, accessory dwelling unit, or employees, year-round employees. People who live year-round in the island. What this case is actually about is affordable housing and parking, whether, and how it's provided and how the comprehensive plan in the town encourages it. It encourages. You can read my memorandum on it.
I have read your memorandum on it.
And I'll leave it with that, but I do have, and I'll quick question again, most in the record. I would like to question Grant and ED that sometime.
Okay. Does anybody have questions for Jen through me? Yes.
Yeah.
Just please use the microphone.
Yeah.
Does comprehensive plan carry the same weight of law as the zoning?
It's an accessory to the zoning ordinance, right? Is how you describe it?
To,
The
de-
guide.
in order
The
to,
guide.
well, in response to the arguments that were made by the appellant and the comprehensive plan does not govern what uses are currently allowed. The zoning ordinance does.
Any other questions for the zoning?
Jen, what are the uses currently in existence on the Dutch property?
There's a single family dwelling. There's there are two 513 accessory dwelling units.
Are those legal uses?
Yep, yes. And one was just approved by a special use permit.
Does the zoning ordinance establish minimum parking requirements for residential uses?
Yes,
Does it establish maximum parking requirements for residential uses?
no,
Does the zoning ordinance in fact allow parking of up to 20, of less than 20 vehicles on a lot without a special use? As long as it complies with provisions of section 502 and 503.
I don't have that ordinance in front of me, so I'm not going to agree with you on that one or respond.
The zoning ordinance requires special use permits for parking in the residential area zone for 20 spaces or more.
Well, there's a section about large lot parking areas.
And that- again, that's-
And it is over 20
Both of those-
20 or more vehicles.
Please let her finish her answer.
And it is over 20 or more vehicles.
Does the code permit residents?
I don't have an answer to that. I don't think so, but I don't know that.
Madam Chair,
Can't,
Madam Chair, if I could just
Yes.
offer something, to the extent that the parties would like to offer evidence, I certainly think that this is the appropriate forum. But if we're going to start asking additional questions, I don't know how far we're going to get tonight.
Okay. okay.
I will say, I would do that the parking, that the zoning ordinance is silent as to the issue of whether you can rent parking spaces or not, and that you have to enforce the zoning ordinance. It does not address it.
We're not talking.
Right, but it's, yeah, okay. All right. Anybody else have questions for Jen? All right. Okay, I'll open this up to public comment. Joe, if you'd like to
I have two witnesses
stick to
in
the
their
point,
vote.
please.
Two witnesses in their vote. One is Dee Dee Beck, one is Brad Beck. First witness is Dee Dee Beck.
Could you state your name? And what is your address?
On the island or?
Let's do the one on the island. Do you swear to tell the truth, the whole truth, and nothing but the truth during the course of this hearing? Thank you.
How long have you owned that establishment?
Almost 3 years.
Who owned it before you?
So thanks, day or night.
Do you know how long they owned it before they, do you know where they operated, where they worked? Oh, no, forget.
Yes,
Do you know where they?
from their
worked?
home. At their home. Center Road. Yes,
Do you know how many vehicles they have?
7 for the business. We have 8.
How many year-round employees?
5,
And how many of them live on the property?
4.
Do you provide year-round affordable housing for 4 employees?
Mhm.
Yes.
Oh, I'm sorry, yes.
The operation of the business, well, I'll ask Frank. Do you have any? You handle most business bookkeeping well.
Mhm.
You have any, or is any of that conducted on lot 72?
No,
Do you have any computers or anything set up to organize shipping on lot 72?
no.
I know for everybody.
Any questions for Ms. Beck?
Next week is grant that.
Grant Beck, 1167 Graces Cove Road.
Do you swear to tell the truth, the whole truth, and nothing but the truth during the course of this hearing?
Yes.
Man, would you walk the board briefly through a work day for you and your employees? How you start and how you finish?
Yeah, so the packages come over on the 11 o'clock boat that arrives at 12 o'clock. So let's say around 11:45 is when the employees leave 1167 Graces Cove. There's one employee that does not live on the property. So she shows up around 11:45 and leaves to all meet at the dock at 12 o'clock. Then the packages come off the boat, they get organized into each of the trucks and they get delivered around the island. And once the drivers are done with their deliveries, they head back home.
When do you find out? Do you get notices from shippers as to what's coming in on any given day? If not, how do you find out what you have to distribute?
We find that out when it comes.
When you meet it at the boat?
Yes.
That's the first time you see the package.
Yes.
Do you have any packages shipped to 1167 Graces?
No.
Other than a delivery to somebody who lives there, that comes from the boat, do you make any deliveries?
No.
No further.
Any questions for Grant? Okay,
Thank you.
all right. This is, this is a public hearing, so if anybody has any, Frank, okay, sure. It's okay.
I would just call to your attention that Mrs. Beck said no business at all existed at 1167 Graces Cove Road, in which case they're essentially admitting that there is no accessory use at the property, and therefore parking would not be. The parking that they have, they seem to be taking from 2 buckets. On one hand, I have an accessory use, so I need all this parking and all these people. And then Mrs. Beck said they have no business there, that no business takes place there at all. So how can you say there's even an accessory use on the site? You know, it's kind of convoluted, but I just feel like they're taking from whatever is convenient to justify their position. And so I'll be quiet now. Thank you.
Thank you.
What we're saying is that your ordinance allows in certain circumstances, parking, when up to 20 vehicles, fewer than 20 vehicles, up to 19 vehicles on a lot. It provided parking is suitably screened and suitably remote from the public highway, regardless of use. That's what's happening on this property, that's what the NA's administrator, the zoning officials has accurately found.
Okay, thank you. Anybody have any further questions? This is a public hearing. We do have some letters. We have a lot of letters from abutters, people on Gracie's Cove Road and from the general public. I'm going to stick just to the people that live on Gracie's Cove Road because that's pertinent to the situation. And I'm only going to take excerpts of letters in an effort to save time. First letter of and they're across the board, they were for and again, for the situation against it. It was pretty even. But the majority of the letters came from people not living on Gracie's Cove Road. It's kind of interesting. The first letter is from Laura and Gary Soul, who live across the street. And this is an excerpt of their letter because they were addressing two things at once. The property is used as a parking lot for Lamb's package service delivery vehicles, and the granting of this application will increase the traffic and erosion on Gracie's Cove Road. Observation of the property will show that there are already multiple persons living on the property. It is not our intention to be obstructionist, but we have reservations regarding the use of Gracie's Cove Road outside of the intent of the zoning regulations and extend into commercial purpose zoning. I do not believe this is considered commercial. Thanks for your attention. We have a letter from Kessis Schaefer, who lives at the beginning of the road. I'm writing in support of the Becks being allowed to park their work vehicles on the property. My house is at the intersection of West Side and Gracie's Cove Road, and I have for many years either run or walked my dog on the road at all times of the day and have never felt that the driving practices of the land package drivers was anything but exemplary. My garden is close to the road, and there are many times over the course of the summer when I see the vans heading to the dock mid-morning, and I cannot quite honestly say that they maintain safe driving practices as they head out again when they return at the end of the day. She goes on to say, the Becks have thoughtfully obstructed the view of the vehicles from the road, shielding the existence of the vehicles from people walking along the road. As you know, the island is not yet lush, it's lush green self, and I found the vehicles well protected from the street view, even with the reduced foliage at this time of the year. I'm confused about why the existence of their work vehicles on their property is any different from any other island businesses. And then from Gail and Jeffrey Hall, who live across the street, we are writing in support of the Becks parking their work vehicles on their property. The laneway to our property is across from the Becks, and we have never had an issue with excessive traffic in and out of their property. We walk the way daily and have never encountered excess traffic coming from their property. The vehicles are set back well away from the road and barely visible. It appears to us that the employees get in the vehicle, leave the property, then return the vehicle at the end of the shift. My question this was addressed to me and Jen, for both you and Jen as a zoning official and as the members of the zoning board is, what constitutes running a business? If the employees of Lamb's Package Service are not employed on the property, are not passing out and picking up packages on the property, and are not conducting bill paying services or any administrative duties on the property, are they conducting business on the property? And would contractors, landscape architects, realtors, and other business owners who park their vehicles at home with names on the sides of their vehicles also fall under this category of running a business? And again, there were a lot of other letters for and against, but these are the only ones in the neighborhood. Okay, well, anybody else have any comments before I close the public hearing? Any questions for anybody else? Okay, I'll make a motion to close the public hearing and take it under advisement.
Second.
All in favor? Aye. Okay. Done our decision, we have to have a discussion. We don't have to have a discussion on anything.
Really don't have to have a discussion. I don't think we needed this.
We don't.
Or a decision. There is no decision.
Well, that's what I'm looking for.
It was my understanding at the top of this meeting that the motion was heard and carried to hear the matter.
You
Therefore,
have to make it.
there would be some sort of decision that should come from hearing the matter. Just in that, with the caveat of everything I said before
Right.
about the standing issue.
Right. So this is not a fun.
You're free to leave, but the board is gonna continue with the meeting.
So. Did I close it again?
We did, yes.
I'm so like, my
Yes,
head is
we closed
my
it.
head is spinning
we
from
did,
this.
we did. We closed it here.
Yes, okay.
We're done.
Okay,
We're done.
so, but we should render a decision on it. It's not. I would like to know, I feel that we need to render a decision. No, we went through this all.
Yeah.
It doesn't, I mean, there was at one point you said that we put ourselves in Jen's, like, shoes essentially, like go through the findings.
Correct. The role of the board, courts have interpreted what your role is, how you need to approach an appeal of a zoning official determination. And they have said that the idea is that you would need to put yourself in the zoning official's shoes and make the determination that's being asked of you.
Mhm.
Says we must examine all the facts. And the evidence, and make a determination, we must make a determination.
I mean,
Make a motion to support the zoning officials' findings.
Second.
All in
any
favor?
discussion?
Yes.
Is it possible?
The
I
hearing's
think, like,
closed.
It's closed now.
We're closed. The hearing's closed. Nothing else can be.
I second, yes.
We voted.
Any discussion? No, we didn't vote yet.
Okay.
No discussion? All in
No.
favor?
Aye.
Aye. Thank you, everybody, for your patience.
Approval of
That was-
minutes.
Oh, we have minutes. I didn't read them. We don't have minutes.
We didn't get them, yeah. Motion to adjourn.
I'll second that.
That will be,
What?
that'll be done. That's what's for you as far as